marijuana instead of demonizing it as a scourge on society. And that's when I brought it. Now, it wasn't successful for reasons I'm going to mention, but you've got to have the right time to do it. Judges live in this community. They read newspapers, they watch television, they are community members. And if they don't feel that the time is ripe, they're not going to do it. And nobody, I'm not saying nobody, very few people will go out on a limb to invalidate something which is largely popular in society, because then you're criticized for, ruining society. Nobody wants that reputation. So, with that in mind, let me talk a little bit about what we've been able to achieve. Oh, good. Okay. So, Section 7. The saga of Section 7 starts very early, way before the courts even kind of crystallize the elements of a Section 7 claim. To have a principle of fundamental justice, there are 3 criteria that were articulated in the Pot cases of Malmo, Levine, Kane, and Clay. Very simple, hard to apply. 1, it's got to be a legal principle. Can't be a political theory principle. You tell me the distinction, but that's fine. So 1. 2, there must be societal consensus. That's an important principle. And 3, it must be defined with some degree of precision, because you're not going to create a constitutional standard that's too malleable. So, way before the court even talked about what are principles of fundamental justice, the late 80s and early 90s is kind of the bedrock foundation for this. And this is how it developed. First, you all know the mens rea issues, because that's what everybody goes, oh, the Charter is going to transform our legal system, because Vaillancourt struck out constructive murder. Little did people know or talk about that Canada was one of the few jurisdictions that still maintained this draconian form of homicide, so we were just really cleaning up. There was only one other jurisdiction that had it, the United States, right? So I'm not sure it was a big development, but it was exciting. I was teaching, I remember when the judgment came down, I actually changed my entire course in criminal law. So I thought, we're in a new era now where the Charter is going to create minimum standards for fault. Well, that didn't live very long. For those of you who don't remember from law school or doing cases or whatever, shortly after Vaillancourt and Martineau, the courts start going, that idea of subjective fault we said is indispensable for murder. Well, it doesn't really apply unless there's a high stigma to the offense or a high penalty. And then since that day, the Supreme Court of Canada and courts of appeal find every crime not to have high stigma. Like sex assault does not have sufficient stigma for subjective mens rea. There may be other reasons why you don't think subjective mens rea is appropriate for crimes of sexual assault, but it's not because it's not stigmatizing. And then I thought the stupidest line was in a case called Creighton in the 90s, where they're looking at manslaughter, and they said, oh, the stigma is appropriate. I didn't even know what that meant. What is an appropriate stigma? And by the way, manslaughter to me always sounded worse than murder. I always thought manslaughter, before I was a law student, meant mass killing. And I think a lot of people think that. So no stigma. So the mens rea experiment using Section 7, it was a little bit hollow, quite frankly, but it was quite exciting. So then I think the next big development was Morgentaler. Huge case. Invalidated the abortion provisions, and we still don't have any replacement. Okay? And people thought this was a triumph of the concept of a right to choose. A right of a woman to choose, to terminate her pregnancy. Well, go back and read the case. It has very little to do with that, other than the decision of Madam Justice Wilson. It's a procedural case. It's completely about substantive due process as procedural due process. It's about the regulatory scheme they put together for abortion was so obstacle-laden that literally if you lived up north where they didn't have committees to approve it, you would have to take it to term or do it illegally or something like that. So the big case that was supposed to be the turning point, again, wasn't really, because it was pretty much restricted to the procedural frailties of the parliamentary scheme. So then the third one that came down 1 year later was the prostitution reference, which I revisited, 25 years later. This goes to the point about picking your cases carefully. They created a communication law, communication on public streets, to solve a crisis, because there were so many sex workers on the streets of Toronto, Vancouver, Victoria in the 80s because of a case called Hutt. I don't know if you guys remember that, where under the old law, to be guilty of solicitation, you have to be pressing and persistent. So obviously the message was to sex workers is be, hi, how you doing? And not go, come on, come on, come on. So the police couldn't enforce the law. And so there's a crisis. They created this communication provision, which sounded like it violated free speech. And lawyers filed constitutional challenges within the first year. And it all went up to the Supreme Court of Canada, and lo and behold, they just get rid of it because it was a stupid case. It wasn't right. You didn't have the right forum, you didn't have a malleable doctrine, you had nothing. And you had no legislative facts, none. Lawyers often feel that their advocacy skills will be sufficient to convince a judge to invalidate an offense. Good luck with that, okay? I don't care how good you think you are. They need to feel there's some foundation, empirical foundation for what they're doing and not completely abstract. So I don't know if you remember the case, but they actually raised economic liberty, the right to make a living as a sex worker. Really. That was the argument in front of the Supreme Court of Canada. Oh, and it got better. They raised vagueness. I've done a study, and vagueness is the most referenced doctrine in the Charter. I don't remember my numbers, but I think it's been raised 55 times. And it's only succeeded once in a case dealing with bail, not even a substantive criminal law offense. So the prostitution reference in 1990 was too early, too grasping. The Charter had not developed to the stage where they could understand any argument about it. In the same way, the gambling argument I made, I'd love to bring it today, and I bet it would be successful. Because I think the court can understand the argument now, which they couldn't in 95. Plus, Section 7 and its rule of law considerations started to grow. Because the last case that I want to mention in the early days is also a disaster. It was Rodriguez. Another case about a right to choose, just like Morgenthaler. And, you know, I teach the case, I studied it endlessly, I wanted to get involved in Carter, I didn't. And I've never really understood the case, what the court's saying. Ultimately, they're just saying is, yeah, you know, it's kind of controversial, we're not really going to engage in the autonomy consent issues, you know. There's vulnerable people that need protecting, even though there was 80 different ways to protect them other than the blanket prohibition. So the early days were kind of hit and miss with Section 7. But what started to change was a bunch of really kind of absurd cases that created this rule of law consideration for how you can attack legislation without just saying, the legislation sucks. Because ultimately that's what those arguments were always trying to do, masking it in legal doctrine, but the law sucks. So the court gave us some tools in the mid-90s that ultimately culminated in Bedford and in Carter and in Insight. Those are three huge invalidations. Well, Insight's not quite invalidation, but huge cases. So what happened was, it started in Rodriguez because the court started talking about invalidating laws that are arbitrary. They didn't really define what arbitrary means, but I think the expression they use bears little or no relationship to the government objectives. So you can't challenge the objective, but you can challenge the means chosen to achieve the objective. And then a couple of years later in Haywood, and then replicated in the late 90s in Demers, they created overbreadth, where, you know, the objective's good, but your circle of criminality is way too broad, and you're sucking in a whole bunch of innocent people that shouldn't be there. Which is interesting, because the overbreadth doctrine comes from the US, and this is what uniquely Canadian. It was only a free speech doctrine, but we use it now for all liberty claims, so we really didn't quite understand the American limitations, thank God for that. And then you had arbitrariness, also resulting in invalidation of the prohibition on private insurance in Quebec, Chiali. And by the way, if you don't think Chiali is just judges expressing their political views on public versus private insurance, then you actually think law is way more autonomous than I think it is. But the arbitrary tool is an easy way for a court to say, hey, I like your objective, but the means chosen is irrational. And you know what? It's not that hard to argue over something being rational or irrational. It's not completely in the eye of the beholder, but it also has a certain degree of malleability. So with that in mind, with the sort of development of rule of law arguments, I started to try to push even harder. So as I mentioned, the first foray was the gambling one. Fine, it didn't work. That rule of law argument simply wasn't good. But then I tried it in the pot cases, and this is where I thought it got interesting. I wanted to argue not rule of law. I wanted to basically argue that the pot prohibition is stupid. So how was I going to translate that into a principle of fundamental justice that didn't use words like imbecilic, stupid, foolish? So reading a lot of government reports through the 70s and 80s, and commissions like the Wilmette Commission in '69, Criminal Law in Canadian Society, which is a 1982 Government of Canada publication, they all kind of say the same thing. Criminal law is a blunt instrument, I've already mentioned that should be reserved for serious instances of harm to others or society. Criminal law should not be used as a tool of social control simply to instill certain moral values into people. It's about preventing people from harming one another. So, I went to court armed with a lot of legislative fact evidence about pot and the harms of pot. And, really the whole pot issue since its prohibition in 1923 is really a much ado about nothing thing. It's pretty damn benign, okay? And the evidence is very supportive of that, so I felt pretty comfortable. But I had to convince the Supreme Court of Canada that there's a principle of fundamental justice called the harm principle, that if there is a sufficient level of harm inherent in an activity, the government can't use the criminal law to restrict your liberty. And I actually thought that'd be the easy part of the case, and the harder part would be the court going, I don't like your Columbia study. I don't think that shows that marijuana has no immune impairment. They love to say, the jury's still out, Mr. Yonge. You're really, overextending yourself here. But they didn't have as much trouble with the facts as they did with the law. And I actually didn't argue it in the Supreme Court. My father was in a hospital. I couldn't go. So my co-counsel, Paul Burstein, very good criminal lawyer in the city, took over. It's always very hard to argue someone else's submissions, and I was going to start with all the facts and things because I know them best. And Paul told me, I said, how'd it go? He said, oh, it wasn't so great. I said, why? He said, I stood up and I had your notes, and we're going to talk about the history of the prohibition and the benign nature, and I couldn't get more than 10 words out. And then he said, I think it was McLaughlin, he said, where's this harm principle you get? Where's it coming from? This is the problem with advocacy. That wasn't Paul's portion of the argument. That was going to come later. So we actually didn't have an answer. And sometimes when you're hit with a question in court, it's sometimes hard to retrieve the information you want. You're struggling, you know it's out there, it doesn't come to your head. Because, it's an easy answer. I listed a bunch of things. Caesar Beccaria. Anyone know who Caesar Beccaria is? The father of modern criminology. Everything changed in 1782 with his book Crime and Punishment. One of the reasons why capital punishment was banned in Europe is because of Caesar Beccaria. He created it in there. That was picked up by John Stuart Mill on liberty, famous English social philosopher. So, it sounds political. Young's just trying to do a political principle. Well, here's some names that sound more legal. Blackstone. It's in Blackstone's commentaries in the 18th century. Criminal law should be reserved for serious harm to others or society. It's in Bentham, Jeremy Bentham, the great utilitarian philosopher. But more importantly, it's in the Government of Canada publications. I even just read you the Law Reform Commission, blunt instrument to be used with restraint. It repeats itself endlessly in government publications through the 60s, 70s, and 80s. Yet the Supreme Court of Canada had the audacity to ask co-counsel, where's this coming from? And because he didn't have a good answer, that's the decision. In 200 pages or whatever it is, it's a long decision. Ultimately, it all boils down to, we don't know what this harm principle is. And that's why they go on to say, it's got to be a legal principle, consensus, and precision, because they killed us on the legal principle. And I still don't know what's a legal principle versus a political postulate. I don't know. But it wasn't that successful. But here's the thing. Out of disasters, always something good comes. And by the way, that's not my attitude to life. I'm actually far more pessimistic. I'm just trying to be kind of motivational and inspirational right now. But in any event, I have this weird quirk. When I argue a case, I usually don't read the decision for months. I can't quite explain why that is. I kind of know what's in there, right? And I always go to the end of it. I don't know why that is. So I didn't read the pot cases for months. And one day I thought, I better see what happened to all these cases. And I'm reading it, and there the court creates something unintentional that's become huge in constitutional litigation. how it happened was this. If you read the judgment, you don't get a sense of this, but it's kind of funny. We made an argument that the law is arbitrary because it impairs young people's ability to have economic opportunities and to travel as a result of the criminal record. And that's just an unfair burden to put on young people because of their choice to consume marijuana. They didn't like the argument. So they got rid of it, not by just saying, we don't think that means it's arbitrary. They went on, and they didn't have to say this. They said, look, if you're going to say the law is hurting people, okay, and that's a problem, you can't just say the law is disproportionate in terms of the harm it's creating versus the benefit. You got to show that the law is grossly disproportionate in terms of the harms created versus the benefits. And I'm reading this and going, I don't even remember those words being used in any FACTA. And I did watch most of CPAC, and I don't remember anyone talking about it. They basically wanted to say, you got a stupid argument because you're actually asking us to invalidate a law because people are hurt by their criminal records. Well, guess what? Everybody has problems with criminal records. You want to say the law hurts, it better be grossly disproportionate. So, I'm reading this at the same time that I'm noticing the Robert Pickton fiasco in Port Coquitlam, where they're digging up the bodies. And at the same time they're digging up the bodies on Pickton's farm, they caught the Green River Killer in Seattle, who is the most prolific serial killer in the United States. Like most of them lie, like Henry Lee Lucas, I killed 200 people. Don't know. He killed 48 sex workers. Actually, let me read what he said, his confession when he was caught, because this is kind of why Bedford was brought. If I can find, oh yeah, here's the Green River Killer in 2003. I picked prostitutes as my victims because I hate most prostitutes and did not want to pay them for sex. Fine, that's the psychology. But here, I also picked prostitutes as victims because they were easy to pick up without being noticed. Because you got to go to dark alleys to keep away from the police. I knew they would not be reported missing right away, right? All the missing women on the Highway of Tears, and et cetera, and might never be reported missing. I picked prostitutes because I thought I could kill as many of them as I wanted without getting caught. So it's this weird conflation that I'm reading the pot cases saying, hey, you can't attack law unless it's grossly disproportionate. At the same time, I'm reading about serial killers preying on sex workers. And I'm thinking, does the law contribute? Well, Greenaway, or Gary Ridgway, the Green River Killer, thought so because he knew the police just weren't enforcing the law or caring about missing women because they're all just low-status people in society. So I thought, oh my God, there's your gross disproportionality. A law that's designed to prevent nuisance and offense. And the harm is death. Increased morbidity, increased mortality. And that's why the case was successful and was given to me on a silver platter by the Supreme Court in the pot cases when they felt they had to create a doctrine to address our arguments and didn't really think of the implication. And guess what? It's been powerful. It's the same basis for Insight, the safe injection cases. It's a good big part of Carter and assisted suicide, and it was really the essence of the Bedford ruling, even though overbreadth, that rule of law consideration also played a large part. So, I mean, one of the lessons too is that virtue of patience. Bedford, well, I didn't have much choice in Bedford. I actually wanted to do the sex trade challenge as my first Section 7 case. But the prostitution reference in 1990 made it impossible to do. And I had to wait a long time. But in waiting, it gave rise to what we know about all the missing women and Pickton, the Green River Killer. And then I checked further, and by the way, and I just want to tell you, because I didn't know this when I checked, we've known about this a long time, okay? Yeah, the case I did kind of raised some awareness of the issue, but the statistics the empirical data that I was collecting was all like at least 10 years old. And in 1995, Juristat did a report on street prostitution and said in 5 years, 63 sex workers were killed, 60 of them women. And we knew all this. It's like nobody's going to talk about it because nobody cared. But the Supreme Court of Canada gave a malleable doctrine, amazing legislative fact record. I've only mentioned the one Juristat. I should also mention that StatsCan calls sex work an occupation at risk in their homicide reports. What are the other occupations at risk, anybody? Sex workers? What do you think? That's it. That's actually really interesting, but no one would care about that. Yeah. That is probably true. Really? You can't think what they put in there? One is for political reasons, occupation at risk, obviously, even though the numbers shot are actually much lower than you think. And the third is kind of obvious if you think about it, and it is true, taxi drivers. So in any event, Bedford was an easy case to show that the law operated in a contradictory, arbitrary way. It was overbroad in that it was targeting women who were independent, autonomous sex workers who had no trouble taking care of themselves and did things in discreet ways. But there was the gross disproportionality that led to pretty much a uniform victory in 3 levels of court and a 9-0 decision in the court. I knew it was a powerful claim when I started it, but I didn't realize how powerful it was because people probably didn't think much about how the law creates the dynamic and situation where women are put into very dangerous situations. And it's not good enough to say you don't approve of their choice morally, you know? It's like the question I was asked constantly that bugged me when I did the case. I was in debates like, oh, what would you do if your daughter wanted to be a sex worker? You know, I hate that shit. And so I never really knew what to do. So I said, I don't have a daughter. You know, so I avoided the question. But then I finally realized what the answer is. I probably wouldn't be thrilled. I don't like the idea, but I sure as hell would want her to be safe in what she's doing and not have the law expose her to risk. And you know what? A lot of conservative people would agree with that statement. A moral aversion can never trump jeopardy to your life. So, I got a few more minutes, so let me keep going. So, one of the big issues with substantive due process in the reviewing of merits of law is this problem we have with criminal law, and it rears its head continuously in these cases, which is the scapegoating of innocent people so that we can affect government policy. Let me give you an example. Medical marijuana, he mentioned. What's medical marijuana all about? It's really about a blanket prohibition on drug use that effectively has deprived seriously ill Canadians of a medicine that actually works for them. How it works? God only knows. I mean, we really don't know much about the mechanism of action. But what we're doing is we're scapegoating the people that are innocent medical users to support the government's absolute prohibition. Because governments think very black and white. Legislation tends to be very black and white. Really hard to capture the nuances and conditions of humanity in legislation. So, what happened to some medical marijuana, so you know, because it's interesting because it never happened after this, is we ended up in the Court of Appeal of Ontario with both the recreational challenge I just mentioned and the medical case simultaneously. And they were both argued simultaneously. This is kind of weird. We were arguing for invalidation of the possession offense based on Section 7. The medical argument, which I was also involved in, was very different. Constitutional exemption from the marijuana law for the sick person. And I thought that made sense. The court fused the two together on their own, and they rejected our invalidation based on recreational use being protected, but then they go on, instead of saying constitutional exemption, which I think is the biggest problem that we have in our constitutional realm, that we don't exempt people, we invalidate laws that have good aspects. But they basically said, we're not going to give a constitutional exemption because the Supreme Court frowns on it, so we're going to say that we invalidate the possession and maybe the production offense unless the government comes up with an exempting program to get the medical people out of the criminal law. So you have your little card saying, hey, I'm not a criminal, I'm a legitimate marijuana smoker. So that was a remarkable ruling, which we didn't even ask for. And this idea that the government has an obligation to fix their law, add something new, create a program which caused them enormous hardship, or they lose the law. So just to show you how it'll never happen again, so the government passed a law within the 1 year called the Medical Marijuana Access Regulations. It was so bizarre. You could grow for yourself, which a lot of sick people, come on, seriously, growing for yourself. It's not as easy as you think. Or you could hire one person to grow for you for free. Nobody's going to grow marijuana for you for free. And if they're going to grow, they're going to grow for a group of people and have economy of scale and then bring prices down. So we immediately went to court. Actually, is your firm again? I forgot. It was also Joe. Yeah. In a case called Hitzig in 2003, saying, hey, they passed something, but it's defective. And now I was in my moment of glory because I could say, because it's defective, you said 2 years ago, there's no more criminal law if you don't have a valid medical program. And I thought, gotcha! Like, I really felt good about this. Also, the other things they had, you have to have like 3 specialists for some diseases. Try to get 1 specialist, you know. So in any event, the panel was presided over by Doherty, and Justice Lake Rosenberg was there, Mark Rosenberg. You know, some pretty good criminal law heavyweights. And I guess they sort of saw that their decision 2 years earlier was a little too bold and dramatic. So instead what they did was invalidate very specific portions of the new law, and they said, now the criminal law is saved. And I thought that was sort of a very dramatic change of perspective, and also showed you can only push courts so far, and they don't want to necessarily get rid of an entire law just to protect certain people that are more deserving. But you got the same thing in all these cases that deal with liberty and substantive review. Rodriguez, what's Rodriguez about? Think about it.